Looks like everyone is ready. It's my understanding Mr. Marso will be arguing for the applicants, is that correct? And on the other side, Mr. Livingston? Yes, sir. Okay, thank you. Mr. Marso, you may begin.
May it please the court, Mr. Livingston. My name is Steve Marso. I represent Officer Susan Farrell's family in this case. And the dispute in this appeal is over the public duty doctrine. And it's a doctrine that under which this court over 100 years has consistently held that there's two relevant questions to the analysis. One, did the government act in its governmental capacity or its proprietary capacity? And two, were the government's acts misfeasance or nonfeasance? Now recently this court has acknowledged that there's been confusion over the doctrine, its framework, its scope, and this court has attempted to clarify that while narrowing the scope of the doctrine. And in doing so, though, it's adhered to those two questions I just mentioned. We believe there's further clarification needed, namely, what's the proper order that those two questions get asked in the framework? And we think this case provides the opportunity to provide that clarification. And we submit the following as the proper order. First question, did the government act in its government or proprietary capacity? If the answer is proprietary, the doctrine does not apply, end of analysis. If the answer is government capacity, that triggers the next question. Was the action taken, was it misfeasance or nonfeasance? If the answer is misfeasance, the doctrine does not apply. If the answer is nonfeasance, then the doctrine applies subject to any other exceptions. This framework is consistent with the results of this court's public duty doctrine cases for over 100 years. It explains their results, including Breeze and Fulps, where under those cases, the government was proprietor of completed bike path projects and sidewalk projects. They owned them. And in this case, the government was owner of an uncompleted project. So it's consistent when it explains Breeze and Fulps. And even if, in this case, the government's actions were governmental function, it was still misfeasance under Breeze and Fulps, especially Fulps. Fulps said that the actions in that case, which were explicit allegations of nonfeasance, were actually misfeasance on completed projects. Here we have an uncompleted one. So this is even a stronger case for misfeasance.
If a third party is the direct cause of the harm, like here we have the driver in the car going the wrong way on Interstate 80.
That issue was inserted by the Court of Appeals in its new test as the first element. And the problem with that first element is it violates Thompson versus Kaczynski and the Colby line of cases. It explicitly says you have to consider the direct cause. So the test itself explicitly violates Thompson versus Kaczynski and Colby that says you can't get into foreseeability and causation analysis on a duty situation.
Yeah, I mean, it seems to me if you take the Court of Appeals opinion at face value, we would have decided Breeze differently if, let's say, the girl had been riding on the bicycle with her mom and her mom went off the side because, oh no, the mom was now the intervening instrumentality, and not sure that's what we intended to say.
Honor, I don't think the existence or non-existence of a third party is relevant to the analysis because it's a causation issue. The Court of Appeals summed up that its first element was really a causation analysis by this statement in its opinion. Here, the instrumentality starts and ends with an intoxicated Beery driving on the wrong side of the road into Farrell's vehicle, killing her. That's a causation statement. We don't allege that. We don't allege in our petition at all. We allege the government defendants engaged in misfeasance that caused the death. The Court of Appeals just said, we're not going to consider those allegations because Beery was the direct cause. Well, here's the problem with their test. Not only is it a causation analysis, it's a one-sided one. So we responded and said, well, we don't allege that. We allege the government's misfeasance caused the death. The response and the government defendants urge, well, we can't consider those allegations because it requires us to engage in a chain of causation analysis. you can't connect the interchange to the wreck without doing a chain of causation analysis. So they said, we're not going to consider that, you lose. However, the court engaged in that very analysis by saying Beery was the direct cause. Now, I'm not sure exactly what they mean by that, because it's, reality and basic legal principles acknowledge there can be more than one direct proximate cause of damage. That's what juries decide. But in this case, the court appeared to say, well, it was maybe the last link in the causation chain, and then it said, as a matter of law, it's the sole proximate cause. That's what the Court of Appeals did. And so it not only violates Thompson and Kaczynski in the Colby line, but it violates the concept that there can be more than one proximate cause, which is not to be determined by courts at motions for judgment on the pleading. So that's the problem with the first element.
Misfeasance or affirmative acts of negligence line up with Brees and Folps, where you had a defective sidewalk or unsafe sidewalk or defective, poor choice to link a bike path that was unprotected?
And we believe even more so. So there's the allegations in our petition are that there was certain contractual requirements that the state and the cities contractually agreed to adhere to. They did not follow those. And then beyond Brees and Folps, which I think were limited to, well, you defectively constructed this or didn't maintain it. So we have that here in a contractual situation, but they took one step further and opened up the interchange, knowing it wasn't finished, including contractually required safety, paint markings, and other safety requirements. So that act is more misfeasance than certainly Folps, and we'd say even more than Brees. So we think Brees and Folps' finding of misfeasance necessarily compels the finding here of misfeasance.
How would your proposed two-part test square with some of our negligent kind of inspection licensing cases, like the city of Des Moines, I think it was an apartment fire case?
Analysis is, okay, is the government acting as proprietary or government function? And I think in those cases where the government has a regulatory authority to issue permits or licensings, I think that falls within potentially a governmental function situation. Because like the driver's license situation in Colby, where they were issuing driver's license, that's a classic governmental function. Construction projects aren't.
Then the city of Des Moines case, I mean, didn't we allow a claim to go forward under those circumstances for the negligent inspection of the fire systems in the apartment?
Duty doctrine was raised in that case. I don't recall that in the Colby line, but I guess Colby held that it was a non-feasance situation, and I think that was similar to what you're talking about, Justice McDonald, is they had the regulatory authority to investigate drivers who want a driver's license, and they didn't do that. So you failed to, I think what this court says, failed to enforce a criminal law or failed to enforce some regulatory authority. I think a housing permit situation would be similar to that, but a construction project's not. And that's the second main problem with the Court of Appeals' new test, is it misapplied the second element. It held that the government defendants who were proprietors of this project, they owned it, who opened it, that was a governmental function. There are private construction projects all over this state, all over this country. There's nothing unique about the government being an owner of a construction project. In fact,
How would you distinguish then between government function and proprietary function?
I think, Your Honor, one needs to go back to the original roots of the doctrine, which I think Brees and Folps is trying to do. And if you go back to the South versus Maryland case, the United States Supreme Court, the first public duty doctrine case in the country, that was a claim by an individual against the sheriff for failing to protect him from being kidnapped. And the court said that the public duty doctrine essentially in that case was to protect the government from claims of nonfeasance in governmental functions relating to breaches of the peace. So failure in this court in Janke, refused to allow the claim to go forward.
Us catching the inmate once they were off the, who assaulted the person while he was fishing, and we said that was a public duty case, no claim because you didn't catch the inmate.
It was a governmental function, housing prisoners, and then it was a nonfeasance claim. You failed to stop him from escaping, is I think how, under the framework, how that would be analyzed.
In that way too, in the sense that the state didn't put up the embankment that was off the road. The argument was there was a statute that required the state to remove or cause owners to remove obstructions like that. They non-feased in the sense they didn't order the embankment removed, but it wasn't their embankment. They didn't build it.
That's the key in that case. They weren't the proprietor of the ditch or the embankment, and the claim was you should have used your regulatory authority to force a private owner to remove that. You failed to do it. McFarland is, as I understand McFarland, is kind of factually complex. The state was not an owner of the project. It was a 28E county city project. The state, and there was a detailed discussion in that the state was the owner of the state's natural resources. That's the capacity it was sued in, not as owner of the project. And the claim was, well, you own the natural resources in this state on public trust. You should have told the county or the cities to remove that dredge pipe. So it really was suing them in their government function as public trust owner of the natural resources, and it was a non-feasance claim that, hey, you should have used your regulatory authority to tell the owners of that project.
Case, because I think I was on the court then, the idea was there were some warning signs up, but the allegation was they were insufficient, and you, state DNR, should have told the 28E entity to put up better signs or something like that.
From our case, Your Honor, in that the state and the cities own this project, and that's what we're suing them as owners, proprietors of that project. So that's distinguishable from McFarland.
I'm trying to think about this doctrine a little bit more, and obviously there's been some confusion. If we look at kind of the restatement third, post-Thompson, why isn't this just kind of a particular application of the normal duty rules in Section 7, Section 36, which is everybody has a duty to exercise ordinary care, including the government, for their own conduct. People generally don't have a duty to prevent harm caused by third parties. And public duty doctrine just says we're not going to impose that additional duty on the government because they do have some kind of protective law enforcement type services. I don't know. It seems like a very straightforward application of the restatement. Can't we just think of it that way? Of we're not going to impose additional duties on the government that we don't impose on regular people, right?
We argue that the court should discard the doctrine, and I think go to that. The problem with the public duty doctrine is it doesn't treat them like the private parties. It gives them more protection. And the Sankey case, our position is it's not a public duty doctrine case. That's a restatement case, exactly what you said, is our argument was that the chief of police should have protected the council people from the shooter. And I think the restatement was applied there and said you don't have a duty to control the conduct of a third party. So that would be our position, is that's where the law should go, where the government is treated, as the Tort Claims Act says, just like a private party, and the restatements would apply. And that, I guess, segues into that issue of should it be discarded and should Colby Line be overruled? And our position is yes. This court, beginning with the Ogg case in 1872 through Adam case, described the public duty doctrine as an immunity. And if the Tort Claims Act eliminated immunity, it stands to reason the public duty doctrine went with it. Now, I understand this court in Colby has said otherwise in the progeny. We respectfully submit that's incorrect. And that conclusion does not square with the fact that the doctrine is an affirmative defense. So if it's an affirmative defense, as McFarland said, as the government defendants allege here, that means that the government defendants have admitted they have a duty to my clients, they breached it, and they caused damage. So there's no duty dispute here. They admit that, but they say they still win. Well, how can that be then if it's a duty analysis? The answer is because it's an immunity defense.
As a particular application of the duty doctrine that would be traditionally applied, wouldn't that reconcile a lot of the conflict in the cases?
If we apply the restatements, then I think the analysis is typically you have a duty, and then the real question, foreseeability, goes to breach and causation, which I think Thompson and Kaczynski's point was there should be more jury trials over these issues, and court shouldn't be disposing of them on pleading motions. And so, yes, I mean, I agree that if you get rid of the doctrine, then we're talking about the typical negligence tort that private parties deal with all the time. And our position is that's the way the law should go, and that the Tort Claims Act got rid of the doctrine because it is a defense. And I think once you admit it as a defense, I don't think the argument that it's a duty analysis stands up because it's irreconcilable with that. There's other reasons, Your Honors, to discard the doctrine. One, it's difficult in its application. The doctrine's been around for about 150 years, yet we're here today struggling with still what's the framework to use and how do we apply it.
Then we'll give you another crack at it.
I will respond on these issues in my rebuttal. Thank you.
May it please the court. Mr. Marso, Mr. Hermsen. Let me take some of these points one by one. As to the pre-Tort Claims Act cases in which Mr. Marso has suggested that the public duty doctrine was treated as an immunity, it's not. Those are all immunity cases. To misquote a quote, when all you have are nails, use a hammer. And that hammer was governmental immunity. And governmental immunity applied everywhere. There's no need to consider whether a no-duty determination was necessary until later. After the Tort Claims Acts came into play, we began to see that the public duty doctrine is actually a no-duty determination. And the confusion in the public duty doctrine that's been suggested by counsel and legal commentators comes from an armchair quarterback position where you can sit there and look at a doctrine over a long period of time and say, from the first case to the current case, it doesn't seem to be the same, but it ignores the way the court works in the common law. The court.
How do you get from Brees and Phelps to this case? That's not very far, because Brees, bad bike path, you're liable, or at least, you're potentially liable. Phelps, bad sidewalk, you're liable. Here, bad interchange, you're not. How do you reconcile the Court of Appeals with Brees and Phelps?
Two things. First, in that evolution of the common law, when you look at Sankey, the court had looked at misfeasance and nonfeasance and determined and quoted that the common law required that foreseeability be used in making a no-duty determination. Thompson, when it was passed, the court adopted the restatement. Says you can't use foreseeability in these no-duty determinations. So the way you get to the difference between nonfeasance and misfeasance, the brilliance of Brees and as reflected in Phelps is that when there's a third-party instrumentality of harm, the government is entitled to the public duty doctrine unless there's a special relationship. And
we're talking about the government failing to exercise a governmental function. That was the language I think I used in Phelps. So if we're talking about the government, failing to exercise authority to tell a property owner to remove an embankment, something that a normal private citizen can't do, or failing to tell the owner operator of a dredge pipe to sign it properly or to remove it or to move it, again, something a private property owner can't do. But here, they seem to have a reasonable argument, don't they, that it doesn't involve a governmental function. I mean, you get interchanges on private property. And if this thing had happened on private property, you wouldn't have you wouldn't be able to file a motion on the pleadings, right?
Defendants either. Maybe private defendants in a private situation without having the rationale behind the public duty doctrine to limit liability to prevent the government from being insurers.
Duty doctrine is not to leave the government better off. It's to recognize that I think I've explained it or tried to, is not to leave the government better off than a private defendant, but to recognize that the government has additional obligations, additional duties that private citizens wouldn't have, and therefore we're not going to allow tort law to get into those additional duties in some circumstances, at least when they involve issues of nonfeasance. That's I think what it's driving at, not to let a government defendant off when a private defendant would be liable in the same situation.
Suggesting that the government is not entitled to a no-duty determination, which is a central component of all tort law, I'd completely disagree. I mean, there are private no-duty determinations in mesothelioma cases. I cited them in the brief. And the government is in the same position in having the argument of having a no-duty defense. This is just it.
Case, is it Beery or Barry?
Whatever you'd like.
Beery. Let's assume he wasn't drunk, but he went down the wrong side of the interstate because of this interchange and crashes into Farrell. Is it your position the public duty doctrine would bar Farrell's claim in that case?
Maybe you have to restate that. I'll say this, his intoxication status is of no consequence. It's not a material fact or allegation.
Drunk. So same facts other than he's not drunk. He just goes down the wrong side of the interstate. Does the public duty doctrine bar Farrell's claim? Because he's the instrumentality. In the same car crash,
A case that's is on further review or pending and was...
Crash, does it bar his claim?
No, I don't think so. So that would be like...
Sense when you have two people in a car accident and the doctrine bars the claim of one person, not the claim of the other person, and the cause, or at least one of the causes, is the interchange.
The court is required under the restatement to articulate a principle and policy that it follows in making no duty determinations. Not ad hoc, not cases involving foreseeability. And so if I can change some facts and look at Breeze or Fulps, let's look at Fulps. Sidewalk case, plaintiff falls on sidewalk, the government's instrumentality and is harmed. Public duty doctrine does not apply. Fulps is walking on the sidewalk and trips and falls into a plaintiff, and the plaintiff is injured. Public duty doctrine applies. Makes absolute sense because as all of these cases, the recent modern public duty doctrine cases state, when there's the instrumentality of harm, that's a third party, you have no obligation to protect them under the restatement.
Me on that is that the theory requires that we view it as only one instrumentality of harm. But what if you've got a contributing factor is a very confusing interchange that can fool drivers sober or drunk alike?
train itself to making a no-duty determination without confounding it with issues of causation or a scope of liability or breach, which would be later reserved for the jury. We're talking about the first threshold question of whether there's a duty.
And if in the bike path case falls off the bike path,
Onto a passerby. Yes.
kids on the back seat or in the baby carrier. No, the kids. If her kid's in the baby carrier, the kid doesn't have a claim because it's the mom's fault. I mean, that can't be right.
Doesn't make sense, then the modern standard from Breeze and Phelps dealing with instrumentality of harm as the resolution for the conflict between misfeasance and nonfeasance loses traction.
Distinction what Justice Waterman said, which is if the government contributes in some way as a causal factor in the link, then its liability can be then it can be liable unless the thing that's causing it is some sort of affirmative duty to act that's imposed because of its existence as the government. So here, I get it. Beery may have been a cause, but the interchange may have also been a cause, and that's a jury question, right?
Not under the way the restatement's read, and you have to remove yourself from the tendency to use foreseeability in determining whether there's a duty in the first instance.
Statement is kind of takes a pass on public duty. I mean, I think there's a comment that says we leave we take no position on public duty or something like that. And so I don't think you can find, one way or the other for the public duty doctrine. But isn't the distinction between the public duty cases and the ones where it doesn't apply, where when the government, because it's the government, has to go out and do all kinds of regulatory things and catch bad people and stop bad actors and tell people to do things that private citizens don't do. And when they don't do that, when they commit that kind of nonfeasance, we're not going to hold them liable in tort because they'd be writing checks all the time. That's essentially what the public duty doctrine, I think, says.
Constructing interchanges in public roadways as a governmental function that no private citizen is going to undertake to build a Grand Prairie Parkway.
On that then, so your opposing counsel says that the first step is proprietary versus governmental. What is your response to that? And how would, if that were the test, how would you determine whether something is governmental or proprietary?
I'd ask the court to be sure to look at the petition to see if there are any allegations that would substantiate a claim that the governmental parties were acting in anything besides their governmental role. Two, I would ask the court to look back at the prior district court and court of appeals levels to see if the proprietary corporate position was advocated or whether it was raised for the first time on further review. Third, I guess, this is no corporate proprietary project in building roads that are open to the public and serve the public interest. Does that answer your question?
Well, so in your view, when does the government have a proprietary function?
I'm not sure that I could say when the government acts in its proprietary function, but when they're building interchanges.
In Phelps?
Purposes?
Was the sidewalk in Phelps
The public sidewalk, yeah.
governmental or proprietary?
It's a governmental action because it's being created for the public as a whole. And general members
Apply their
there because the instrumentality of harm was the sidewalk. The plaintiff was injured by falling on the government's instrumentality.
your instrumentality.
It arises from Breeze, which was wise enough to harmonize prior cases and to determine that where things between nonfeasance and misfeasance can be pled either way and may be a gray area. The one thing we know is that when it's the government's instrumentality that causes the harm, it doesn't apply when the government's instrumental.
Said that. I mean, I don't know. I mean, you're right. The Court of Appeals came up with that, but I agree that, you know, these cases, two of which I take ownership of, I wrote them. Actually, I take ownership of all the ones I joined, are not the clearest thing in the world, but we've never said that. It seems to me public duty would be if you know, if you were in court representing the state or the city of West Des Moines because a police officer or a DPS officer had failed to pull over Barry and stop him before he got going on this road and crashed into the patrol car, that might be a good case. That would be a good public duty case, but not for building a road. Yeah.
I think that might be a little bit of the distinction. Isn't there a distinction between when the government owes a duty to, through regulation or whatever, to control the conduct of a third party? That's when the public duty doctrine might come into play, when they don't protect you from a third party, when they have some kind of regulatory function to do that. But when the third party is independent of that duty related to the government function, then I don't see a basis for the public duty doctrine to come in
this case, because it is a protection that would otherwise make the government the insurer of highway and roadway safety. Ensuring that one motorist will operate safely, follow regulations, and not cross and damage another person.
37 of the restatement third play here.
Remind me, 37.
Whose conduct has not created a risk of physical or emotional harm to another has no duty of care to the other unless a court determines that one of the affirmative duties in section 38 through 44 is applicable. And then the comments to that section say, that's the point where you make the public duty determination, is that you're not going to impose an affirmative obligation on the government and force it to be liable for risks of harm created by other people just because it has general law enforcement duties. So it seems to me that would reconcile these cases and solve the problem of where two people get in the same car accident, and what you're saying is one can sue the government and one can't, even though they both allege the same negligence. I mean, it doesn't make sense.
To the determination of duty in the first instance. And I see that my time's expired, but I would request the court to be very careful in waiving Section 7 Thompson and the public duty cases, which find when an instrumentality of the government is the harm, no public duty, but in McFarland and Ross and Colby and Sankey, where there's a third party that is the instrumentality of harm, the public duty doctrine applies. With all due respect to your authorship and joining in those opinions, Your Honor, perhaps from an outsider's perspective, reading those cases with fresh eyes would establish that the instrumentality harm is one of the main factors and the reconciling factor that was identified with Breeze. Thank you.
Thank you. Back to you, Mr. Marso.
Thank you, Your Honors. In Fulps, this court defined nonfeasance in a way that I think it encompasses the framework I laid out early. It said nonfeasance is nonfeasance in failing to discharge a public duty. I think by that statement, what the court's saying is there has to be two requirements before the public duty doctrine applies. One, it's got to be a governmental function and not a proprietary function. And second, it has to be nonfeasance, not misfeasance. So I think Fulps supports the framework that we're urging here, and that I think this court's case law provides. Another hypothetical is what would happen if same facts, except instead of the car collision, the vehicle in which Officer Farrell was traveling swerved and it hit a governmental bridge pillar. In that case, it would seem under the instrumentality of harm test, the public duty doctrine wouldn't apply because the last link in the chain was the bridge pillar, assuming it was misplaced or, put in the wrong place, let's say, for example. And so there was a basis to argue fault by the government. So I think the hypotheticals show that this might be an easier case that the doctrine does not apply, especially after Breeze and Fulps, but there's going to be difficult cases in the government versus proprietary misfeasance and nonfeasance. And
To go to that issue then, between government and proprietary, your opposing counsel says that building roads is very much a governmental function. Explain to me why it's not.
they define the function too narrowly. Anytime the government acts, if you define it, say, well, the government builds a government road, or the government puts on a government-sponsored fair, and a private party can't put on a government fair or build it, it's too narrowly defined.
Different than a fair. I mean, most roads are not.
I mean, most, but there's private roads.
Make that distinction when there are things when a government can do and that a private sector could do, but generally it's a government function. So how do we make that demarcation?
Those things that only the government is authorized to do: issue driver's license, arrest and imprison people, respond to fires and put out fires, and issue building permits. Those things that I think are pretty easy cases, and I think South versus Maryland is an example. There's some other examples from this court. The Ogg case was an argument failure to stop the spread of smallpox. That was a classic governmental function. There was a Wilson or Van Horn case, said failure to adequately respond to a fire. Those are government functions. Being an owner of a construction project is not. That is a proprietary, they own the road. That's the distinction, I think, but I guess my point is that it can be a difficult question in certain instances, I agree. And the misfeasance, nonfeasance can be too, which I guess supports the idea that the doctrine should be discarded. It's difficult to apply.
Because I have serious stare decisis issues with that. But if we worked with the Court of Appeals, this instrumentality of harm, don't you win? Because one of the instrumentalities of harm is this poorly designed intersection or interchange where you're driving on the wrong side of the road and it lacks the markings and lighting and they open it too early and all that. Isn't that a classic misfeasance? Okay.
Yes, it is. I mean, if misfeasance occurred in Breeze and Fulps, where they were completed, especially Fulps, this is clearly misfeasance under those cases because it was unfinished and they opened it up. They affirmatively created the problem. So yes, I think it is. And if the Court of Appeals test was going to be adopted where you're going to engage in a causation analysis, then you have to acknowledge that this interchange can be one of the causes. And so we would win under the Court of Appeals test as well, Your Honors. But you know, it's difficult to apply. It's been around for 150 years and we're still struggling with it. You know, and it's increasing this court's increased involvement. This is the 8th case since Colby. In contrast, in Youngblood, this court overruled longstanding precedent over a dissent that said it's the first time we've addressed this issue in 28 years. Eliminating the doctrine is not going to create automatic government liability. Plaintiffs still have to prove breach, causation, and damages. The government has other immunities under the Tort Claims Act, and there's no evidence there'll be a parade of financial horribles. Between the Tort Claims Act and Colby, there's no evidence there was a parade of financial horribles. This court's Colby cases don't use that as a justification, and if that did occur, the legislature, the branch that should deal with this, can address that. That's all I have, Your Honors. Thank you.
The state of Farrell is hereby submitted to the court, and court is adjourned for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.